Thank you, everyone, for joining today's webinar. It's being co-hosted by the Rising Arbitrators Initiative and the HK45. So this webinar is part of the Rising Arbitrators Challenge series, in which we explore the different issues that practitioners often face in their early days as arbitrator. Today's session is focused on Asia, and I'm very happy that we have a very distinguished panel of speakers joining us today. Dr. Yang, Professor Kim, Mr. Pullen, and Ms. O'Hara. But before we begin, let me just address the housekeeping matters first. The session is being recorded. Participants' lines have been muted, but we very much encourage questions. So if you have any questions, please do make use of the Q&A function to send them through. And let me start by giving a very short introduction of our speakers. Professor Kim is a professor of law at the Yonsei Law School in Seoul. And among his long list of achievements, one that I picked out is that in 2019, Professor Kim was named the International Arbitrator of the Year by the KCAB. Dr. Ling Yang is the Deputy Secretary General of HKIAC and the Chief Representative of the Shanghai office. Before joining HKIAC, Dr. Yang was an associate professor at the East China University of Political Science and Law and a visiting scholar at a number of prestigious universities. Ms. O'Hara is a partner at Nagashima, Uno, and Chunametsu. Ms. O'Hara acts not only as counsel, but also sits as arbitrator in many international arbitration cases. Ms. O'Hara is very active in IBA activities and was previously the co-chair of the IBA Asia Pacific Arbitration Group. And last but not least, Mr. Pullen, who has a very diverse career history. So Mr. Pullen was in private practice for many years as a solicitor in international arbitration, but he is currently a barrister and an arbitrator based in Singapore at the Fountain Court Chambers, again, focusing on international arbitration. So with that, I would open the discussion. I will first start by inviting each speaker to share what their first arbitral appointment was like. And for Dr. Yang, given your role as a representative of an arbitral institution, I would also invite you to tell us a bit more on what arbitral institutions are doing, HKIAC specifically, for rising arbitrators.
Thank you, Joanne. And thanks a lot for the co-organizers, Rising Arbitrator Initiative and Hong Kong 45. It's my great privilege to participate in this important event. So thank you so much, Joanne, to let me, as the first speaker, to introduce HKIAC's support to the rising arbitrators. So I will take these 5 minutes to try to share 3 points for this part. The first point is about the statistics of HKIAC in 2020 about the younger or newly appointed arbitrators. The second part, I will be introduced how HKIAC support rising arbitrators. And lastly, if I have time, I would like to introduce my personal tips for the rising arbitrators generally. And if time allows, I would also like to share my personal tips for those who want to seek appointments in mainland China. Okay, for the first part, so maybe some of you may know that last year is a record year for Hong Kong IAC, and for the specific part of the appointments made by either HKIAC or by co-arbitrators, we can see from this slide, we saw the greater diversity, and of the 149 appointments made by HKIAC last year, there were about 50 half of the arbitrators are not the other arbitrators not previously appointed by HKIC over the last 3 years. And the number of the geographic origin or nationalities of all arbitrators appointed by HKIC of last year is 17. So second part, I would like to share how HKIC support rising arbitrators. I would like to share some initiatives of HKIC or some current regimes in HKIC. The first one, maybe some of you know that HKIC has several lists for arbitrators. Among those several lists for arbitrators, there are one specific list we call the list of arbitrators. For those part, so the candidate arbitrator needn't to approve any arbitrator's experience, but need to approve the rich experience in international arbitration. So beside of this list of arbitrators, HKIC also have another specialized arbitrators. We have a panel of arbitrators for those who have rich experience as arbitrator. We have IP, intellectual property dispute resolution, and financial dispute arbitrators. And we also have emergency arbitrators list. And the second, I would like to introduce HKIC's support for the rising arbitrators because this is one of our very proud of the program. We call HKIC's Tribunal Secretary Service and the Tribunal Secretary Training Program. So some of you may know that HKIC is the first international arbitration institution in the world to offer the Tribunal Secretary Training since 2014. The training, the Tribunal Secretary Training Program typically takes 2.5 days, and the participants who have passed the assessment at the end of the day will receive a certificate and will be listed on HKIC's website subject to the participants' consent. So over the last 6 years, HKIC has conducted this Tribunal Secretary training around the world, including New York, Singapore, Mumbai, Shanghai, Beijing, Tokyo. So if for the young arbitrators who want to get their first appointment, I would suggest that Tribunal Secretary might be a very good choice or the gateway to the arbitrator. And the third initiative or the third part of the HKIC's support to the young arbitrators, I would say that HKIC has several initiatives to support the different groups. So such as Hong Kong 45. So today's event was co-organized by Hong Kong 45. And last year, I can give you one example. Last year, Hong Kong 45 conducted a webinar series in mainland China, which has attracted more than 10,000 people to review those webinars, including some training part for arbitrator. And the second initiative I would like to share with all of you is the Women in Arbitration Initiative. This is the new initiative launched by HKIC 3 years ago. And this group the aim of this group is to promote the female arbitrators in the region. And every year, Women in Arbitration, WA, conducted several trainings, webinars for young generations, practitioners, and arbitrators. Last but not least, how many minutes I have? Maybe 1 minute, Joanne. So I would like to share some of my personal tips for the rising arbitrators in general. And tip number one. So I understand today that the audience come from the 37 jurisdictions. And I should say, I understand the different audience have different background. So I should say tip one, all the skills are transferable. No matter you are professors or in-house or from the institution. So be confident all the experience can be transferable. Tip number two, Tribunal Secretary. If you didn't get the first appointment, try to be the Tribunal Secretary for the more experienced arbitrator or tribunal. And to attend the arbitrators training program. So I want to give some information for the mainland Chinese practitioners. HKIC this year, I mean 2021, HKIC will be conducting the tribunal arbitrators training in mainland China. Please follow up our website. And the tip number 4, that put your name on the list or somewhere. For example, you can put your list on HKIC's list of arbitrators, or CTAC, or KCAB somewhere. Or if you can't, please try to put your names on some good initiatives. For example, Rising Arbitrators Initiative, committee member, women in arbitration, executive member, something like this. And the tips number 5, so promote your peers. So okay, different age have a different difficulties, I should say. So for us, so we are trying to get our 2nd, 3rd, the 4th arbitrate appointments. But if you get a chance, if you acted as a counsel, please try your best to promote your peers. Please try to promote your young arbitrators at your same age, so you will get the same feedback. And last but not least, to be confident, be efficient, be diligent, be responsible, and most importantly, be visible. Try your best to speak, to publish everything you know about arbitration. So that's all from me. Thank you, Joanne.
Thank you, Dr. Yang. I think that's a great start to the discussion that we're about to have, and I'm personally very excited to hear about all these developments going on at HKIAC. So perhaps to start, can I also invite the rest of the panel, maybe say a few words, and just looking back at your very first arbitral appointment, what was it like? For example, did you also have like the benefits from institutions like what Dr. Yang outlined just now?
Perhaps I'll begin. It's a great pleasure to be here. I'd like to thank the organizers. I recall back in the day, I was getting a bit impatient for a while, and I was wondering, God, am I ever going to be invited to sit as an arbitrator? And I was wondering and wondering, and then boom, all of a sudden, this email comes in and asking for a conflict check. And I recall I was actually a bit lucky in that I got like 2 appointments within like the span of a couple of days. And one was for an institution that everybody knows that's based in Paris. And another one was actually an institution based here in Korea. The one based in Paris was interesting because I had one of the first cases where I actually had 2 sets of initials at the end of the case number, because it was a case that was originally housed in Paris, and then when the new Hong Kong office was set up, they added the other counsel's name, which is actually the same initials as my wife, so I always have to remember those initials. And then that was an appointment by someone that I'd known for a couple of years. He appointed me as a party appointed arbitrator. And for the local institution, I was actually just appointed by the institution. All 3 members of the tribunal were appointed by the institution.
Yeah, what about Mr. Pullen or Ms. O'Hara?
Shall I jump in? Thank you. Thanks, Joanne, and thank you very much to everybody who's organised the event today. It's a pleasure to be talking to you and yeah, to share my experience, such as it is as sitting as an arbitrator. And it's interesting, so thinking back to my first appointment is not so long ago, because my career, much of my career was as counsel, and as Joanne explained, I started off as a solicitor. I worked for Allen & Overy for many years, then I made a change and switched to being a barrister at Fountain Court Chambers, and my first appointment as an arbitrator actually came just at the point that I was making the switch. And in fact, before we had officially announced that I was open for business at Fountain Court, I had the inquiry from I'm going to name the name, the SIAC in Singapore, who gave me my first appointment. And it's interesting to think about how did I get that, because actually well, I got that partly because I had applied to their panel sometime before that, whilst I was still at Allen and Overy, and I had been approached a number of times before that, but I think about three approaches over the course of sort of 6 or 12 months or so since I'd started being interested in sitting as an arbitrator, but in each case had run into issues of conflicts. Either I couldn't accept the appointment, or I would have to make a disclosure because of something that somebody else somewhere in the firm, elsewhere in the world was doing, which meant that the SIAC didn't want to go ahead with the appointment because they wanted to put somebody forward who could put in a clean statement of independence, because they were all sole arbitrator nominations that they were dealing with. And so that was my first appointment, and I think that illustrates both the challenge I think that many people who are watching who are at a law firm, particularly a big international law firm or one that's very active in an international arbitration, may find that stymies some of the initial approaches, and obviously it became easier for me once I was in independent practice to do conflict checks and to clear them. But I think it's probably also sort of worth just hanging in there if you do run into trouble a few times, that eventually something will come through that you can say yes to, and you'll get your chance. I think the second thing is the importance of the institutions in providing opportunities to new arbitrators to sit. As Dr. Yang was mentioning in relation to the HKIAC, I think the institutions do provide a lot of the first appointments for people, and in fact over the sort of last few years whilst I've been sitting as an arbitrator, my appointments, ultimately the appointments have all come from the institutions. I've had a number of inquiries by counsel who wanted to appoint me or put me forward, but for one reason or another it's not matured. It's always been the institutional appointments. So I think it emphasizes the importance of the institutions for widening the pool, and if you're an aspiring arbitrator, to make sure you're in touch with the institutions and they know who you are. So that was really how I got the appointment. I think then I was going to share a couple of things. One was the biggest challenge with that first appointment, and then I think what I got out of it. And I think the biggest challenge I found with that appointment was that it proved, not in terms of the subject matter, but it proved to be quite difficult to manage because the council on one side in particular, it seemed to me, were not particularly experienced in international arbitration, and there was a real issue of a language barrier, and so that made it really quite difficult to manage. We might talk about this a little bit later, but that was a real challenge to try to explain what was going on to them, and so that caused a number of difficulties as the proceedings went on, and eventually that party replaced their counsel with somebody else who was a Singapore law firm, which made it actually incredibly incredible difference in terms of how much easier it was to manage the proceedings. Then in terms of what I got out of it, I think I did get quite a lot. First thing is that I confirmed that I did actually enjoy sitting as an arbitrator, and so was interested in sitting again and taking on further appointments. And I actually think working through the issues and making a decision was interesting and enjoyable, and obviously a different experience from being counsel, where you're advising or trying to argue the case. Ultimately, you have to make a decision. And I found that actually in itself quite a rewarding experience. But also I found that it's been useful for then reflecting back onto my activity as counsel, which is still the bulk of my practice is as counsel rather than as arbitrator. But I find the fact that I've been sitting as an arbitrator is useful for thinking about how better to approach things as counsel. So two quite interesting things I got from that appointment and the others that I've had since.
And what about Ms. O'Hara? I imagine you may face quite a lot of the same issues as
Yes.
Mr. Poulin, conflicts especially.
Yes, well, first of all, thank you very much for inviting me to sit as a panelist together with this esteemed panelist. All being said, all the other panelists have been already, comprehensively share their experience, and I simply echo what they have said, but I can, just briefly explain my first experience, a first appointment. I have been, just like Andrew, Mr. Pollen, I was approached by a number of major Japanese companies, but due to conflict, I was not able to accept co-arbitrator position. Eventually, my first appointment finally came when, the local arbitration institution, which is JCAA, appointed me as a sole arbitrator. And just like Mr. Pollen's case, it's a challenging case. It's a sole arbitrator, and it's challenging because, one party was defaulting. So you have to make sure the procedure will be in line with due process, and arbitral award can be enforceable. And what was more challenging is because in the middle of the proceedings, a party who claimed to be the parent of the respondent show up in the proceeding and mess the whole proceedings. They claim they are the legitimate respondent, but they are not the party to the respondent. That they are not, identified as a respondent, but the parent of the respondent. So you can imagine how, proceedings are quite complicated. And also as a first, sole arbitrator, you consult with the arbitration institution, and you manage to issue an award at the end of the day. And I was so, grateful when I heard that the arbitral award was finally enforced in the United States. So it's a challenging experience, but at the same time, it's quite rewarding. And Mr. Pollen mentioned, you learn a lot by serving as an arbitrator. And, when you serve as counsel, you sort of understand what would be the good trick to persuade an arbitrator. So that's the interesting part of arbitration. When it comes to judge or court proceedings, you do not really switch between counsel position and judge position unless in certain common law jurisdictions you serve as attorney at law all the time and represent your client during your career. But in arbitration, you can switch counsel and an arbitrator. That is the quite interesting part of arbitration practice, and you learn a lot, and it's quite rewarding. Thank you.
Thank you. So Dr. Yang mentioned visibility just now, and Professor Kim and Mr. Pullen also mentioned, having links and relationships with institutions. One question I have is that for arbitrators or aspiring arbitrators, you spend a lot of time building relationships, professional relationships, social relationships with others in the arbitration circle. My question is, how does one ensure that your perceived impartiality isn't compromised by these relationships? Maybe that's one Professor Kim can address.
Yeah, I think this is a very interesting question. You want to have relationships, but of course, you don't want those relationships. There's a concern that those relationships might become an issue. I think that the simple answer is, the newspaper test. So whatever you do, if you feel that it's comfortable that it's on the front page of the newspaper, then you should be able to go in and do it. If there's any hesitance whatsoever, I think the safest route is you just disclose it. That's so I tend to, some suggest I over disclosed, but I feel more comfortable with that. So there's always this fine line. And the other issue I think that comes up, strangely enough, is the opposite problem. And what I mean the opposite problem is sometimes I find people that I know are too conscientious. So I've been actually I've heard these situations where my name was being considered, and then one person was, oh, actually, I know that person, so we just should exclude him. when, just the fact that they know me, maybe they had a bad impression of me, that's a different question. So I feel that some people that are not as knowledgeable about arbitration are hypersensitive about potential conflicts, when if you were kind of an expert or in the field, you'd know it's not a real serious issue. So I've actually encountered that problem as well.
A few tips, if I may. I think, Professor Kim made a great point. Another tip I usually follow is, in addition to newspaper test or disclosure, I try to, get along with those people in a group, not, individually. So make sure that they are witnesses that which can testify that you are not doing anything wrong at all, and all conversations are heard by third parties, to make sure that there will be no perceived bias or perceived conflict of interest.
I was going to add, I think there's another element of this, I think, is relationships generally within the arbitration community. And if you're attending conferences, if you're attending events, speaking at events, sitting on boards or committees of one sort or another, you will get to know people, and those are legitimate contacts, and they may lead to people putting your name forward as an arbitrator. If in my position, I go around and perhaps not the last 12 months, but in normal times, I would go and visit people in different countries that I know if I'm there. But I have to say, primarily looking at my counsel role and sort of looking at potential instructions in that field, and then if some of them end up being arbitrator appointments, then that's great as well. But I would sort of see that. I think then some people I know who are full-time arbitrators are perhaps a little bit more wary about going to somebody's office to, if you like, for a sort of marketing meeting in the way that I think is perhaps is certainly not a problem. I feel for me, in terms of the practice I have and the bulk of my work. But I know some people feel more sensitive about that, and I think people have to make their own judgment. But that's the sort of relationship in general where it's obviously legitimate, and you've got contacts with people. I think then when you're sitting on a case with counsel on a case, then you've got to take a step back and be more cautious. And so there was an incident where my chambers had arranged a dinner with with some members of a particular law firm, and I specifically didn't go because I knew there was somebody who was likely to be at that dinner, who was appearing as counsel in a case where I was arbitrator. And I thought in that situation, it probably wasn't right to be there at a meeting in that sort of context, or a dinner in that sort of context, whilst the arbitration was ongoing. And so I think you do need to think about that and adapt your behaviour, and certainly for private meetings or private dinners like that, if you've got somebody that's active in a case.
So if I may, I would like to add something relevant. So because disclosure or some perceived impartiality in China is a quite a difficult thing, because maybe in China, the relationship is everywhere. So China is so big, and the arbitration community, the bar association, different associations is everywhere. So for example, I was an associate professor in the university. I should say half of the practitioners in Shanghai are my students. So it's very difficult to say I have something with one. But over the last several years, I concluded some experience from mainland China. So if you are the newly appointed arbitrator, before you feel accepted this appointment, if you have something feel uncomfortable about the relationship with one of the counsels, so before you disclose this something, you can consultant, or you can ask the staff or case manager from the arbitration institution, because for those arbitration institutions, they have rich experience to dealing with the disclosure. And this is one hand. On the other hand, the arbitration institution, generally, they don't like, for some of the Chinese mainland arbitration institution, they don't like the arbitrator to give over disclosure, because if the arbitrator discloses something, which means generally in Chinese culture, the counterparty will challenge this arbitrator, which means the proceeding will be delayed, and the arbitral institution wouldn't like this happen. So generally, the case manager will give you some very honest suggestion whether you should disclose this kind of relationship or not kind of relationship. This is one suggestion. Second suggestion, so I have my personal standard message to the councils. If one of my, the council in my community appoint me as an arbitrator in some cases, I have a standard message to this council that please do not click like to my WeChat or LinkedIn, and I will block you until the end of case. So please do not contact me through WeChat or LinkedIn, leave my message. I will never reply about that until the end of the cases. So I think this is a good way to protect the arbitrator and protect the whole cases and make the whole process it's a legal, and the award is can be enforceable. Yeah.
I think these are all like really insightful and very practical tips. One question I have, and it's also a question that has come in from the audience, is how would the situation be different, say if you're sitting in a 3-member tribunal or if you're sitting as a sole arbitrator? So I'd like to get the panelists' thoughts on what different challenges you face when you're either the chair or the co-arbitrator or when you're a sole arbitrator. Maybe Professor Kim or Ms. O'Hara can start. Maybe let's start with the chair first.
Yoshimi, my former chair.
Ms. O'Hara, I think
yes,
you're
okay, yes. Thank you very much. I enjoy sole arbitrator and 3 tribunal members both equally, and each has different challenges and different reward. First, talking about sole arbitrator, you have full control over the entire proceedings. So you don't have to consult with third parties. You can decide when to, have the procedural conference call or, the hearing. It's all up to you how to decide and when to decide. Of course, you have to meet the client's expectation, and parties are the clients in this case. But at the same time, the challenge is precisely because you have to decide everything. Sometimes, particularly when you are relatively new when you serve as an arbitrator, you may wish to consult with somebody else. And perhaps, this is the point when institution can come in, and institution can provide some assistance to young arbitrators who do not have necessarily extensive experience in serving as an arbitrator. So it's rewarding, but it's a challenge, but the institution can come in and help. In talking about 3 members tribunal, particularly, I have a great joy and rewarding experience when I sat as presiding arbitrator together with Professor Kim, because you are enriched by 2 co-arbitrators. You are not on your own. You can discuss and get the benefit of wisdom, experience of other 2 tribunal members. So that is the rewarding part. And if the disputes involve quite complicated matters, cultural difference, language difference, and different legal system, those 3 tribunal members can get together and consult, and based on their own expertise and experience, the 3 tribunal member can come to the conclusion that can be acceptable to all the members. The challenging part is, 3 members do not always agree. because they are coming from different background or legal education, their approach to the case or proceedings could be completely different. My tip is I usually invite them for dinner before the hearing to, get to know each other and to create a good atmosphere, to make sure that one party, one co-arbitrator will not become so, partial. Make sure that 3 tribunal members will form a good cooperative atmosphere. And so far that works all the time.
I've been blessed to have been part of a dinner hosted by Yoshimi. It's one of my proudest moments as an arbitrator thus far. I think just briefly talking about experiences as being a wing and a chair. One thing that's different for a wing, of course, is usually, well, oftentimes, you're involved in the process of selecting the chair. So of course, as the chair, you're not, you're the one that's being selected. So then, finding the right chair is actually kind of part of the task of being a good wing. And of course, working that out with the other co-arbitrator as well. That's an important part. The other issue, I think, as wing, of course, and from my personal perspective, as a lowly professor from a small country in Asia, sometimes I sit where the other co-arbitrator is big name QC, well-known person, and who's going to listen to this professor who's clueless and doesn't know what he's talking about. So I think the challenge as a wing, of course, is you want to be as helpful as possible, particularly to the chair and to the other co-arbitrator, and creating that. Part of creating an atmosphere where you're a team. And of course, as chair, you really want to make sure it is a team effort. I've been fortunate in that so far the tribunals I've sat on, I haven't had tremendous amount of kind of dissension or conflict. I think all the tribunals so far we've had good collegiality. And I think the only difference is the degree of how much we've gelled together. So I've had some wonderful experiences where I've met people I never even knew, where I've been actually become very, very close with. And that's, I think, a very, very rewarding thing. As chair, another tricky thing, of course, is I find is the way I like to describe it is you're kind of navigating a big ship, and you're holding on with a really small rudder, and you have to try to guide the ship in the right way and make sure things are going. Or another analogy would be like a conductor with a really small baton, and you have this orchestra in front of you and trying to make sure everything's in order and all the the harmonies there, and there's no major accidents or unpleasant things going on. I think one thing that's changed in our virtual world is this added challenge of technology. So there's, I think, a lot of different type of preparation goes in now, particularly if you're chair, just working out the logistics and all the technical stuff and time zones, and this presents a totally different challenge that you would not have if it was just in person. So the dynamics and challenges of being a chair are always evolving. One kind of tip that I find has been useful for me, again, you definitely want to be invited to Yoshimi's dinners, but what I suggest is, and this has been actually I haven't had anybody that has not had this, but just always setting up a separate WhatsApp room for the tribunal members. And somehow, even people, I've sat with people in their 80s down to maybe their early 40s and 30s, and everybody has WhatsApp. That's kind of the one thing I found. So just setting up a separate room for that, and then just where you can chat or whatever during the hearing as well. I found that's been very helpful for me so far.
And Mr. Pullen and Dr. Yang, I'm also interested in your experience. We've touched on chair and wing, but I know a lot of young practitioners, when they get their first appointments, they have to do it alone as a sole arbitrator. Any tips you can share? Any challenges that you've faced?
Yeah. Well, I mean, certainly that's been my experience. I mean, my first appointment and my appointments since then have all been as sole arbitrator so far, and it does present challenges. I mean, there are pros and cons to it, which all really stem from the fact that you are on your own. The con is you don't have colleagues who are there who you're able to discuss all of the detail of the case with and sort of chew it over and figure it out. You're going to have to work it out for yourself to a large extent. The big pro is that you can do what you think is the right answer. You can decide in the way that you think, and on procedural matters, and also on the substance. And you don't get into any sort of compromising or issues around that. And so that can, I suppose, on one level mean that you get a clear decision from that person. Of course, what you don't get is the sort of testing of perhaps of your own internal logic that you might get with a dynamic of discussing with the two co-arbitrators. And then I think in terms of other things that I've taken away from the experience, I mean, one I think is already been mentioned, which is to talk to the institutions, because I think there are some things on which the institutions can be really helpful. I mean, particularly if you've got issues about the approach that they would expect to be taken under their rules, or if you want to make sure you haven't missed anything in the rules when you're figuring out how to approach something. I think it's entirely legitimate to speak to the institution and just sort of double check that you're not missing something before you make your decision on that. Ultimately, you will have to decide, but that can be a really helpful resource. I mean, and then I think the other thing, well, there's two other things I would say that I've taken away from my experiences sitting as a sole arbitrator, and particularly starting as a sole arbitrator, is sort of thinking back to my first case again. And I explained the context. I just joined Fountain Court, just switched over to independent practice. So one of the things I didn't have was a big library of precedents that I could go back and consult, for example, for procedural orders. So if you are taking it on in that sort of situation, then you've got to figure out how you're going to go about coming up with your procedural order number one for the arbitration. And to be honest, I went back to some of the training materials that I'd got from doing various arbitrator exams, used that as a checklist, and drew upon the experience I had as counsel to think about, well, what are the issues that need to be sorted out here, and used that as a starting point for coming up with a procedural order. And then as time has gone on, I've then adapted and enhanced that, sort of taking things from other cases where I was arbitrator and also the cases where I've been counsel, and then also from the point of view of not reinventing the wheel, but also getting the parties' input. I have made it a practice to always ask the parties at the start with a checklist of things. Well, what do you think about all of these issues before the first procedural conference? Both because it's supposed to be the parties' arbitration and because they know the subject matter much better than you do at the start, and also because it means you're not starting from scratch. And I think especially when you're a sole arbitrator, that's really helpful because you're not going to get anybody else that can point out things that you might have missed. So that was kind of one major things that I think that I've taken away. And the other thing that I took from the first hearing that I did, where I was going to have to write an award, was particularly as it is just you, make sure you've got what you need to be able to write your award. And so, for example, at the end of that hearing, I went through a list of the questions that I thought were important to be answered, and made sure that the parties knew what they were so that they could address them in their post-hearing briefs. And I thought that was particularly important, because there wasn't going to be anywhere else that I could speak to say, well, what did you think about this? What did you think about this issue? It needs to be properly addressed, because I think this is important, and I want to know the answer in order to write my award.
Okay, before I share my experience as a sole arbitrator, and I should say I would like to join the Yoshimi's dinner in the coming years for the tribunal dinner. And yes, I just want to share the experience of what Andrew just said. For me personally, I think the role of sole arbitrator is more difficult than the co-arbitrator. And I can share some cases I handled last year. Last year, fortunately, I handled 4 cases as a sole arbitrator. Among those 4 cases, all the respondents were not attended, are defaulting, and 2 of them were non-represented, which means 2 of the claimant, the representative is the staff of the company, which means they have no knowledge, very basic knowledge about the procedure. As a sole arbitrator, I took a lot of time to explain to the company staff what is the due process, how should you present in the hearing, and this is quite a challenge for me. And so if I may, I would give some most challenging part to be a sole arbitrator. So generally, for most of the young practitioners, the first appointment from the institution, most of them are sole arbitrator. But the small venue cases doesn't mean the simple cases. So some of the procedure issues or substantive issues are quite difficult. And as a sole arbitrator, which means you have no colleague, no co-arbitrators to discuss when you face some difficult issues. For example, the jurisdictional issues. If the one party challenges, the tribunal has no jurisdiction, and in the same time you are the first appointed arbitrator, you have no experience to handle such jurisdictional issues. So what we should do. And for sole arbitrator, in general practice, in most of the time, which means you should take more time to check the evidence, to ask more questions to the counsel, to know the facts of the case. So which means that you should be very sensible to, on the one hand, procedure issues, on the other hand, about the facts. And just Mr. Poland mentioned earlier that when you draft an award as a sole arbitrator, which means no colleagues help you to check what is wrong, something missed. So from the very beginning, when you accept the arbitration as a sole arbitrator, you must write down from the first day when you read the case file, what's the most important issue you should pay attention to for this case, and write down from the very beginning. And just the point mentioned earlier, I think it's very important to highlight again that please feel free to contact the case manager or counsel. For example, HKIC's secretariat, we are ready to help the newly appointed arbitrator. Please feel free to ask us. And my personal experience is that, so if I have some difficulties with the, for example, the explanation of the arbitral rules, so you can also to ask a case manager, hey, if I understand correctly, I should do it like this. So generally, the case manager will give you a very good suggestion. And for the procedure, my personal experience is that when you act as a sole arbitrator, please ask questions as more as you can before the hearing. So because the hearing is quite expensive for all the parties, including the arbitrator. So please do not leave any important question in the hearing before that in written, and ask all the counsels to answer the question before the hearing and give them evidence to these questions. And the last suggestion, this is quite important for Chinese practitioners. I understand in mainland China, procedure order is something quite new for arbitration practitioners. So my personal experience, it is rare to say the arbitrators to use procedure order to manage the procedure effectively in mainland Chinese arbitration, because most of the procedure are managed by the institution via the case manager. So if you were a sole arbitrator, please try your best to use the procedure order. I have tried this several times. It's quite efficient to manage the case. So in conclusion, ask staff from the secretariat, leave the question list, try your best to give more and more question list before the hearing, and try to use the procedural order to manage the procedure. Yeah, thank you.
I think that's very interesting. What you mentioned just now, like procedural orders aren't as common in mainland China. I wonder if our panelists can share a bit more about what cultural differences do you observe among parties in conducting arbitration. Our panel members are all based in different parts of Asia, so I'm sure our audience would be very interested in your insights on this.
If I may. So I'm from Japan, and talking about arbitration practice in Japan, it is rather consistent with the standard arbitration practice widely accepted globally. But when I sat as the presiding arbitrator in one of the Asian countries, I had a very interesting experience. In that case, neither party produced witness statement, only expert report. But there are factual disputes, and it's really difficult for the tribunal, and all the tribunal members are not from that country. So we are not capable of understanding local language. We are not capable of understanding local culture. And this was all shocking to all the 3 tribunal members. Wow, how are we going to identify facts, you know? And we asked questions to counsel during the hearing. And of course, we invited the parties to produce witness as an evidence to assist the tribunal for fact finding. But neither party was reluctant. And it turns out that this is not necessarily unique to that case. It turns out to be relatively common in that jurisdiction. So it appears that in certain jurisdiction, you know, witnesses are not necessarily produced as evidence in the Asian region. And so tribunal has to be creative to find fact when parties are not willing to produce witness to the tribunal. So that was a challenge in my experience.
Andrew, you want to go ahead, or shall I? Or okay. When I ever hear the cultural question posed, my view is, you know, basically we're all prisoners of our own background. So if you come from a particular background, that's kind of the way you grew up. So that's the way you perceive the world. And you think kind of that's the way things should be done. And that's kind of where things should be approached. And you're biased in that way. And of course, you try to strip yourself of that bias, and you try to trick yourself into believing, oh, I'm actually being very, very fair. But actually, sometimes there's unconscious bias and unconscious cultural differences and perceptions that color your thinking. So I think you got to be very sensitive about this, to try to really open your mind, because, you know, even within Asia, there's so many different nuances. Even if you're dealing with, you know, parties from different continents, there's so many nuances, and you tend to try to pigeonhole. Certain people are like this, certain common law countries are like this, civil law countries like that. And that's just a very difficult kind of process. You got to kind of unwind from your thinking. I think the beauty of arbitration is somehow, despite all of that, and despite, you know, tribunal members probably from 3 different cultures, 3 different legal backgrounds, parties from different continents, counsel from different continents, witnesses from different continents, experts from different continents, somehow it works. But I think it works because the people that are really the most sophisticated about it are able to put that all together and gel together and try to come to the right decision in a fair way. But still, just trying to, get that out of your head and keeping an open mind is the big challenge. So one simple thing that I always kind of bring up is, for instance, when you're choosing a chair. So just a simple example is if there's a European colleague and I'm sitting here in Asia and we're talking about a chair. So if the other party appointed arbitrator is from Germany and proposes somebody from Switzerland, it's like, that's a totally neutral thing. But if I propose somebody from Japan or Singapore, it's not perceived that way. Oh, another Asian, which is actually totally incorrect if you think about it, right? What's the difference? So that's the type of thing that we still face, and that's just the reality of things. It's unfortunate because, of course, that means that they just don't know that there are a lot of really competent people in Singapore or Japan that can handle a case in a very competent, neutral, and fair way. Whereas the Swedens of the world and the Switzerlands of the world, they have that kind of built-in impression and that's maybe their head start. And that's the kind of catch-up we have to do and the perception that we have to kind of overcome.
Yeah, I was going to say, in terms of cultural differences, I think there's probably two main areas which have been touched upon, but it's probably worth just distinguishing them. So I think the first area is in relation to arbitration procedure itself, or the procedure that you're going to follow in your arbitration. And it seems to me that that is going to be largely driven by the background of the lawyers that are involved, whether that be the lawyers who are counsel or the lawyers, and they mostly are lawyers who are sitting as arbitrators, because that's going to drive your expectations, as Professor Kim was saying, as to how you think it should be done. And this is where I think we've all become used over the years to the fact that there are different ways of doing things. There's an element of commonality that's developed across all arbitrations, but there's flexibility, you can adapt it. And it's one of the continuous areas of debates and why arbitration practitioners like to have conferences, so because we discuss it so much as to where the nuances are, as to which bits should be in the commonality that really you see in every case, and where the flexibility should be, and what the innovation should be to make it better. So that's one area of it, I think, and that I think, if you've got people who are experienced in arbitration, you can manage that. The parties might come in with different approaches and different suggestions, but ultimately you'll be able to deal with that. The difficulty comes in the situation that I was talking about before, and I think Mr. Hara was talking about, where you've got or Dr. Yang actually, where you have, say, an unrepresented party, or you have a party that's represented by lawyers who don't really have experience, and therefore the difficulty is that if it's not that you might come at it with a particular view as to how things should be done, and the institution might buy into that, and so might the council on the other side, but that one party might have different expectations about how it should operate, and then that's when you get the difficulties, and that's when you have to really work hard to try to do everything you can to explain what's going on and why you're taking various steps in the course of the arbitration to that party, to try and ensure, first of all, their buy-in, and that they understand that they are getting a fair opportunity, and that you're giving them, and you are genuinely giving them a fair opportunity, and trying to hear what it is that they're trying to say. So I think that's the first area. The second area that I think is on the substance, and this is where there can be cultural differences just in how businesses operate, how business is done in different countries, or how societies operate, and that's something. It's when you're sitting and hearing the evidence, and you've got to try and weigh up, is this plausible? Does this have the ring of truth to it? An obvious and perhaps sort of often cited example of this was, well, are there any documents that support it? And obviously, in many countries, you have you have different levels of formality over how things are done. And so what might be extraordinary in one country, that there isn't a whole raft of documents confirming that such and such a decision was taken, may not be so extraordinary in another country. And that's the sort of thing, I think, where you've got to be open-minded and try and again, it's an element of a balance as well, because it's being alive to that possibility and thinking about that, but also not just sort of having a stereotype that a country that's maybe sort of still a developing country, that there won't be documents, and therefore just assuming that if there aren't any produced, that's purely down to cultural differences, rather than it may be that there aren't any documents and that wasn't the decision that's made. So it's going to be difficult, but you've got to think quite carefully and weigh up the issues on the evidence that you get.
Before I share some observation on the different background, I would like to give some comments on Yoshimi's story about the factual witness. So I want to share with you that over the 5 years, I have been handling around 40 cases, arbitration cases, as a chair, co-arbitrator, or sole arbitrator. I want to say very few cases in my arbitration cases that factual witness be used. So again, I echo all the comments or observations from my distinguished panelists today. But for me, I would like to observe from different angle. I don't think this is just a cultural thing, because a different culture will lead a different regime. For example, we are talking about best practice in arbitration. Everybody here today know what is best practice, unsatural model law, due process. But for those general standard word, I should say, even in China, mainland China, something is still far away to reach. For example, competence. So for example, the hearing or the IBA rules. So these things is quite popular in international practice, but for mainland Chinese practitioner or arbitration, it's still at a very younger or early stage. So now I would like to share some my personal observation, not just on cultural difference, just from some legislation or regime differences on this topic. So for example, because today our topic is arbitrator, so I would like to pay attention to the role of arbitrator between the international practice and the mainland Chinese arbitration. Okay, so for example, in mainland Chinese arbitration, as arbitrator, most of my job is to dealing with the substantive issues. So the procedure issues, for example, the surveys, the communication between the parties and the arbitral tribunal, and the exchange of the opinion between the tribunal and the parties, or to confirm the date of hearing, all those things are handled by the institution via the case manager. So for the role of arbitrator, I should say, I understand Joanne had another question for all of us, is that the different skill set to be an arbitrator in international arbitration and mainland Chinese arbitration. I should say here, so if when I was an international arbitrator, I told myself, hey, you should pay attention on the procedure issues. But when I act as an arbitrator in domestic arbitration or mainland Chinese arbitration, I just stay there and wait for all the evidence from the institution, waiting for all the documents from the institution. And I just sit there and read all the case file and make some decision on the substantive issues. But if there is some problem arising from the procedure, so generally these issues will be handled by the institution. Okay, so this is I don't think this is a cultural difference. This is just the difference between the arbitration regime. So today, I believe everybody knows that mainland China arbitration law is not the unsatural model law jurisdiction. So some unique practice. So I want to emphasize. For example, another example is governing law. So today we are discussing about the international arbitration, which means in different arbitrations, we may encounter different governing law or different seat of arbitration. But for most of Chinese arbitration, the seat is quite clear, China. mainland China. So if you understand the Chinese arbitration law, so generally you can handle the Chinese arbitration perfectly. But if you are a Chinese professional, you got the first appointment in international arbitration. I mean, the first thing for this arbitrator is to dealing with the different seat. For example, sitting in Hong Kong, sitting in Singapore, sitting in New York. So this is the thing, it's quite different for the role of arbitrators. And of course, last but not least, language barrier, the style of hearing, and the days, how many days for the hearing. This is another interesting story. I can share something with you. In China, typically, the hearing is a half day or 1 day. But in international arbitration, 1 week, 2 weeks, 3 weeks, it's quite popular, right? It's very common. But for mainland Chinese arbitration, 2 days is too long for arbitrators, for both councils. Oh, 2 days, half day is left. So this is not cultural thing. It's kind of practice or something that the regime needed a different practice. So okay, due to time limit, I just want to stop here. So okay.
Thank you all. Yeah, those are all like really helpful insights. I'm conscious of time, but I think we managed to cover a wide-ranging set of topics today, which I find very helpful, and I'm sure our audience find it very helpful too. Just to sum up, there are a few tips that I got from today's session. One is being alive to different practices of parties from different backgrounds, and whilst doing so, continue to keep an open mind and not not be dictated by what we are used to seeing from our own background. The second tip is being visible and building a good relationship with the network of contacts, including with institution. 3 is getting help. If you're on a 3-member tribunal, you can get help from your fellow co-arbitrators, but even if you're a sole arbitrator, get help from the parties, get help from the institution. And finally, very importantly, good food always helps. So I think that's a very practical takeaway tip that we all got. So with that, thank you again to all our panelists, and thank you very much to all the attendees who have dialed in. And just to finish up, I would encourage you all to sign up to HK45 and the Rising Arbitrators Initiative. Both groups offer a lot of resources for aspiring arbitrators. So hope to see you all again at our future events. Thank you very much.
Thank you very much.
Take care.
Thank you. Bye-bye.
Thanks very much.